Welcome back to Past Law Exams. This is Misrepresentation, Part 2 of a two-part tutorial. In Part 1 we covered the definition, the elements and the three categories of misrepresentation. Today, we cover remedies. And we begin with a very important recent development in the law. Let's get into it. Before we get into damages, a critical update for your exams. In 2025, the Privy Council, in Credit Suisse, Life Bermuda Limited versus Ivanishvili, changed the law on inducement in deceit claims. The board held that a claimant does not need to prove they were consciously aware of the misrepresentation. It is enough that the false representation caused them to hold a false belief and act on it to their loss. Reliance is now purely a question of causation. This decision is highly persuasive in English law, and you must know it. The remedies for misrepresentation are rescission, damages, and in limited circumstances, an indemnity. An indemnity is only available for innocent misrepresentation where damages are not available and covers only necessary expenditures incurred as part of the contract. This was confirmed in Whittington versus Seale-Hayne in 1900. We begin with rescission. Rescission is available for all types of misrepresentation, fraudulent, negligent, and innocent. It sets the contract aside and restores both parties to the position they were in before the contract was made. But the right to rescind can be lost. There are 4 bars to rescission: affirmation, lapse of time, restitution impossible, and third-party rights. Now let us take each bar in turn. 1. Affirmation. Where a party continues with the contract knowing of the misrepresentation, they affirm it and lose the right to rescind. Long versus Lloyd confirmed this in 1958. This principle was reinforced as recently as 2023 in Krishna Holdco Limited versus Gowrie Holdings Limited. 2. Lapse of time. Where too much time passes and it would be inequitable to grant rescission. In Leaf versus International Galleries in 1950, the gap was 5 years. The right was lost. Salt versus Stratstone in 2015 refined this, confirming that delay alone is not enough. The lapse of time must be unreasonable in all the circumstances. 3. Restitution impossible. Where the subject matter of the contract has been consumed or fundamentally changed so that the parties cannot be restored to their original positions. Clarke versus Dickson confirmed this in 1858. Salt versus Stratstone also refined this bar, confirming that mere depreciation or use of goods does not make restitution impossible. The court can compensate for this and still grant rescission. 4. Third-party rights. Where goods have been sold on to an innocent third party before rescission, the court will not require that third party to return them. Now, damages. The amount of damages available depends entirely on the category of misrepresentation. For fraudulent misrepresentation, damages are available under the tort of deceit. The test for fraud was established in Derry versus Peake in 1889. The maker knew the statement was untrue, or was reckless as to whether it was true or false. The measure of damages for deceit puts the claimant back in the position they would have been in had the misrepresentation never been made. All losses directly caused by the deceit are recoverable, with no rules of remoteness applying. This was confirmed in Doyle versus Olby in 1969 and affirmed by the Privy Council in Credit Suisse, Life Bermuda Limited versus Ivanishvili in 2025. This is the most generous damages measure available, because the fraudster cannot argue that the losses were not foreseeable. For negligent misrepresentation under Statute, Section 2, Subsection 1 of the Misrepresentation Act 1967 creates what the courts call the fiction of fraud. Once a claimant proves a misrepresentation was made, the burden shifts to the defendant to prove they had reasonable grounds to believe the statement was true. If they cannot, damages are assessed on the same basis as fraud. This was confirmed in Royscott Trust Limited versus Rogerson in 1991. Though this decision remains controversial and has been subject to serious judicial criticism at the highest level, the court also has a discretion under Section 2, subsection 2 of the Misrepresentation Act 1967 to award damages in lieu of rescission, where it would be equitable to do so. Salt v. Stratstone confirmed in 2015 that this power only applies where the right to rescind still exists at the time of the award. Finally, for negligent misrepresentation at common law, where a special relationship exists between the parties, damages are available under the principles established in Hedley Byrne v. Heller in 1964. Before we go, your recap checklist. The remedies for misrepresentation are rescission, damages and, in limited circumstances, an indemnity. Rescission is available for all types of misrepresentation, but can be lost by 4 bars. 1. Affirmation. Long v. Lloyd, 1958, reinforced by Krishna Holdco 2023. 2. Lapse of time. Leaf v. International Galleries 1950, refined by Salt v. Stratstone 2015. 3. Restitution impossible. Clarke v. Dickson 1858, refined by Salt v. Stratstone 2015. 4. Third-party rights. Where goods are sold to an innocent third party before rescission, the right to rescind is lost. Now, damages. For fraudulent misrepresentation, all losses are recoverable. There is no requirement for remoteness in the tort of deceit. This principle, established in Derry v. Peake, 1889, and Doyle v. Olby, 1969, was recently confirmed by the Privy Council in Ivanishvili, 2025. For negligent misrepresentation under statute, specifically Section 2, subsection 1 of the Misrepresentation Act 1967, the fiction of fraud applies. This means the measure of damages is the same as in deceit, as seen in Royscott Trust v. Rogerson, 1991. While controversial, this remains binding law. Section 2, subsection 2, allows for damages in lieu of rescission. However, this is only available where the right to rescind still exists, a point clarified in Salt v. Stratstone, 2015. For negligent misrepresentation at common law, a special relationship is required, following Hedley Byrne v. Heller, 1964. Finally, the 2025 landmark update. In Credit Suisse, Life Bermuda Limited versus Ivanishvili, the court ruled that conscious awareness is no longer required for inducement in deceit. Reliance is now a matter of causation only. Want to test your knowledge? Visit us at passlawexams.com for past paper questions, model answers, and everything you need to prepare. Subscribe to Pass Law Exams for more tutorials. Pass Law Exams, because passing is the only option.